Hey dears, welcome to my channel. This is Priya Karnagaran. Hope you all are doing good. So in this class, we're gonna discuss about Droit Administratif. First, we will see the meaning of Droit Administratif. It's a French administrative legal system, which means a body of rules which determine the organization, powers and duties of public administration. And it regulates the relation of the administration with the citizens of the country. Independence of the administration from judicial control, the ordinary courts cannot exercise control over administrative functioning. Administrative tribunals supervise administrative functioning. It does not represent the rules and principles enacted by the parliament, but the rules are developed by the administrative courts. It regulates the relationship between public servant and citizens, public servant and government, public servant and public servant. And next we will see the concept of Droit Administratif. The body which is structured with the rules brought in by the administrative courts is attached to the name of Napoleon Bonaparte. The atmosphere surrounding the French Revolution of 1789 was mainly associated with the chaos between the traditionalist Bonapartists and the reformist parliaments. While the former was in support of the supremacy of executive powers, the latter preferred the jurisdiction of ordinary courts only. The two bodies that overtook authority from one another during the pre and post-revolutionary. France were then recognized as the Conseil du Roi and Council D Etat respectively. Conseil du Roi. It was a product of pre-revolutionary France. This body acted as an advisor in legal and administrative subjects for the king. Along with the executive function, Conseil du Roi also performed judicial activities which included settling disputes between the nobles of the nation. It was in the 16th century that the judiciary was slowly being overshadowed by the growing power of the executive in form of Conseil du Roi. Autonomy on the part of Conseil du Roi proved to be detrimental for the ordinary courts. Such discriminatory excess of power in the hands of executive was limited as the atmosphere slowly changed from pre to post-revolution in 1789. The revolutionary change that was brought about during the post-revolution is the restriction of power confined in the hands of the executive. Such changes was regulated by the concept of separation of powers. This subsequently resulted in the abolition of Conseil du Roi under the governance of Napoleon Bonaparte, who was a supporter of reforms and freedom on part of administrative actions. It was gave birth to Conseil D Etat in 1799 with an objective to eliminate difficulties in administrative courses. In the course of time, Conseil D Etat started looking after judicial matters as well. Although the motive behind the formation of Conseil D Etat was to remove suppression of the judiciary by the executive, the influence of the executive could not be totally done away within this case also. The appointment of the members was carried out by the decree issued by the executive, which required the consent of the Council of Ministers. Therefore, the judiciary till then was unable to access its freedom and authority by itself. This council deals with a variety of matters like income tax, claims for damages for wrongful acts of the government servants, personal claims of civil servants against wrongful dismissal or suspension of servant, and then last one is disputed election. The jurisdiction of Conseil D Etat was decided to be final in all administrative matters by the Arrets Blanco, which was the executive law during 1873. It was decided that if any conflict would have arisen between the ordinary courts and that of the administrative courts. The same was supposed to be settled by the Tribunal des Conflicts, which was presided over by the Ministry of Justice and involved an equal number of judges from both courts. The development of Conseil D Etat was on the basis of its own doctrines with the functions of regulation of excise amounts of administration against the citizens. And then we will see rules in Droit Administratif. It does not involve in it the rules laid down by the French Parliament. It consists of rules developed by the judges of administrative courts. It includes 3 series of rules. The first rule is rules dealing with administrative authorities and officials. It deals with appointment, dismissal, status, salary and duties. And then the second rule is rules dealing with the operation of public service to meet the needs of citizens. Public officials are under their supervision or private agencies. And then the last rule is rules dealing with administrative adjudication. And then next we will see 3 principles of Droit Administratif. Valin is a French jurist, propounds 3 basic principles of Droit Administratif. The first one is the power of administration to act suo motu and to impose directly on the subject the duty to obey its decision. And second one is the power of administration to take decisions and to execute them suo motu may be exercised only within the scope of law, which protects individual liberties against administrative arbitrariness. And then third one is the existence of specialized administrative jurisdiction. One speaks of administrative jurisdiction because his decisions relates to the superior control of the Conseil D Etat, either by means of appeal. And then we will see features of Droit Administratif. Matters concerning the state and administrative litigations, so administrative codes. In above said matter, special rules developed by the administrative courts are applied. And then third one is Tribunal des Conflicts. It conflicts of jurisdiction. And fourth one is Conseil D Etat is the supreme administrative court. And then it protects government officials from the control of ordinary courts. And the last one is the French Droit Administratif has sought to draw a balance between private rights and the public benefits. On the one hand, it maintains and supports administrative powers. On the other, it will develop a mechanism for protecting individual rights and civil liberties against possible attacks by the public authorities. And then the next topic is drawbacks of Droit Administratif. The first one is Dicey's criticism. British jurist A.V. Dicey once expressed his views that there is no rule of law in France due to droit administration. He thought that droit administration is in contrary or opposition to the rule of law, but it appeared he was mistaken. And then the second drawback is, although it is true that an individual in France, while dealing with the state on any issue, does not stand on the same footing as that on which he stands in dealing with his neighbor. Moreover, the government and its officials are independent and free from the jurisdiction of ordinary courts. Despite these drawbacks, the droit administration has been quite successful in subjective rule of law in France. And that's it, dears. Thank you. Hope you all understand the concept that we have discussed in this class. So if it was useful, give thumbs up to this video, and most of you have not yet subscribed, so please subscribe to my channel and tap the bell icon. Then only you will get notification while I am uploading the other concepts.